Joining me now, George Washington University professor of law, a Fox Business contributor, Jonathan Turley. Such a pleasure to see you as well. Jonathan, where does this go from here, this decision?
Well, first of all, there's a number of states that do have these types of added burdens to get permits. Those laws are presumptively unconstitutional. It depends upon their language. But the court here is very clear. In fact, clarity is what is so strong about this opinion. And that is, it's clear that you can't put the burden on the citizen to make the case to use a constitutional right. What the court is saying is that that burden belongs with the state or the city to justify limiting a right. And Justice Thomas says, just what other individual rights do we require permits to exercise after showing some particular need for the right? The second area of clarity is that the court says, look, there's no difference between your Second Amendment right in the House and outside the House. This is an important distinction used by various states. And the court said, no, you have a right to possess a gun. And, you know, the state has to make the case why you shouldn't have that right. Now, it's also important to note this isn't some runaway train. The court says that this is not an absolute right, that there are sensitive locations like polling places you can limit possession. But the court is very clear again that this is an individual right like the other individual rights in the Bill of Rights, and the burden does not rest with the citizens to enjoy them.
How do these laws in states like New York, because for now it still stands, so in the states where this would have a real impact, this Supreme Court decision, California, District of Columbia, and 8 states, including California, Hawaii, Maryland, Massachusetts, and New Jersey, how do those laws fall, if you will?
Well, they can't really be enforced. To the extent that they contradict this holding, they are invalid. And so any effort to enforce them is going to presumably result in a very quick reaction from a trial court. Now, it was interesting that Governor Hochul in New York immediately said, well, we're just going to start passing new laws, which was somewhat humorous because New York has been actually very good for the gun rights advocates. I mean, they've lost some tremendous cases. They just lost one of the biggest cases they have lost in history. So promising more of the same is not necessarily going to be condemned by gun rights advocates. They would like more of the same. But she noted, you know, we'll just work on what's a sensitive place. And it's one of those baffling moments again. Why would you say that out loud? It's like playing poker with your cards facing outward. I mean, if you immediately after the court strikes down your law, you say, well, we're going to try to create a new loophole using the term sensitive place. Well, that's the court will note that like they noted the history to this law.
Right. I was talking about the history. What is she going to decide? That the sidewalk is a sensitive place? That you're not allowed to carry a weapon? If you have a permit, if you've gotten a permit, gone through the process, that the sidewalk is a sensitive place or a drugstore is a sensitive place. Are they going to be that granular with it? And I pointed out that, go ahead, Jonathan.
No, but that's actually the history of New York, is that they passed these laws for this sort of immediate gotcha moment, and then they create bad law from their perspective. It's important to remember that the case before this one, the New York politicians said, again, we're going to fight this all the way to the Supreme Court, even though many of us said that law was also unconstitutional, and they pulled the law. And they ended up pulling the case right before the court could rule on it. And it infuriated some of these justices who felt these New York politicians were just gaming the system and playing voters. And so it's one of this legacy from New York that you would think that voters would begin to say, you know what? We need to be a lot more sensible and a lot more restrained in how we pass these laws.
And I noted that this goes back to Tammany Hall and Big Tim Sullivan. About a century ago, and they were corrupt, and they were gang overlords, and it was about making sure their gangs doing their bidding had arms, but rival gangs who were not lining the pockets of these Democrat politicians were disarmed by this law. And also there was an issue of law-abiding citizens who had weapons, who were tired of the gun violence in the street, who were targeting these gang members. So it was never about public safety in New York, ever, not based on this law.
No, it wasn't. And the really fascinating thing is that over a year ago, I wrote, and a number of people wrote and said, look, this is just breathtakingly unconstitutional. This doesn't come close to what Heller said. And they did what they always did. They created this circular firing squad and decided to litigate this through the federal courts. And now New York has created one of the greatest losses for gun control advocates in history.
Jonathan, great to see you. Thank you so much. I am going to go and apply for a concealed carry permit and see what happens, just out of curiosity, see how it goes. I'm sure it's not going to go as smoothly as, well, who would ever expect anything in New York goes smoothly, but we shall see. I know some famous people who used to have concealed carry permits, but it's because they knew somebody, which is exactly what Shannon was talking about. Jonathan, thank you so much.
That's right.
Such a pleasure.